Masechet Yevamot of Sadi Aleph. Today we are going to continue and finish the list of 16 penalties that the woman gets that we've been analyzing, and after that we're going to go into the sefa of the Mishnah of the three dissenting minority opinions here and the sefa. So we're up to this one, number 12. That says, Haita bat Yisrael nifsela mina kehuna. A woman, actually any woman, but even a bat Yisrael, can no longer marry a Kohen, and the bat Levi cannot eat maaser, and bat Kohen cannot eat teruma. In other words, if such a woman remarried thinking that her husband was dead, and then the original husband comes back, so they would receive all of these penalties, including these three. So let's analyze them. Pishita, isn't this obvious that she cannot marry a Kohen? That is the definition of zona. If a woman has an extramarital affair, even if it's unwitting, she is not allowed to go back to her husband if he's a Kohen. If it's on purpose, then she cannot go back to her husband even if he's a Yisrael. So here, regarding here, it's unwitting, but still she cannot go back to a Kohen. We know this halacha already. This is the basic halacha. Why do you need to tell it to us? And the answer is actually we just need it for parallelism. Bat Levi min ha'maaser yistarich aleh. We really want to talk about the next phrase, that Bat Levi has a consequence too. She can no longer eat maaser. She can no longer eat maaser. Even if she goes back to her father's house, that's it. No maaser for her. Now we ask, Ubat Levi mina maaser mi pasla biznut? Wait, is that true? Is that a halacha that if a bat Levi is engages in some kind of zinut, illicit relations, does that make her no longer able to eat maaser? It's not true. If a bat Levi was taken captive, and we worry that while taken captive, her captors will take advantage of her, or if she engaged in relations that were illicit, nevertheless, we give her maaser and she can eat maaser. So what does it matter? Amar Rav Sheshet kenasa. And the answer is really, that's not the halacha. This is just yet another penalty that the rabbi said. We want to add more penalties, more than are actually absolutely necessary according to any deoraita law, because those penalties will at the end will scare her off from the beginning from taking a risk of not checking to make sure that the husband is really dead, so that they can be lenient and allow her to get married based on one witness. Right? Remember the Resha, when the rabbi said yes, you can get married. That's based on one witness. And therefore, we want to be mekel, but we can only be lenient and allow her to marry if we impose these penalties at the end, so that there will be serious consequences if, in fact, the husband is alive. Okay, so that's one of the penalties. Now, next, bat kohen mina teruma, afilu b'teruma d'rabanan. So the bat kohen cannot have teruma. Isn't that obvious? Of course she couldn't. If she's zona, she cannot have teruma. And the answer is, the rabbis are adding something else, even teruma that's only teruma d'rabanan. Like if it was in a pot with no holes in it, that teruma d'rabanan, even that she cannot eat. Next, ven yoshin shel zeh v'yoshin shel zeh yoshin ketubata. The inheritors do not inherit her ketubah. What is this talking about? Ketubah, my abidata. What is the purpose of this ketubah? Why are you mentioning it here? I know that she doesn't collect. What are you talking about? The inheritors of the ketubah. Amara papa ketubat benin dichrin is talking about, there's a clause in every ketubah, even if you don't write it, it's implied that should she die before the husband, the amount of the ketubah will be inherited by her sons. And so a ketubah that she, from the first husband, or a ketubah that the second husband wrote for her, either one, if she dies, those sons will not collect the amount of the ketubah. The purpose of this clause is to make sure that her sons are taken care of, because the husband might have other sons from other marriages, so that it's coming to her. So when she dies, this goes to her sons. In this case, she loses it as one of the penalties. Now we ask, Pishita, isn't this obvious that she would lose it because she doesn't have her ketubah? She doesn't get the ketubah, so of course the kids won't get it. So why do you even have to say it? The answer is, no, I might have thought that we only, for her, she's the one that violated a prohibition that she was with two men and married to one of them, and the other one is a problem. So therefore, she deserves this penalty. But her children, you might say, did not do anything wrong, so they don't deserve a penalty. If she died, okay, that's it. We're done with her. The children didn't do anything wrong, so maybe they should be able to collect the ketuvah. And so kamash malan, this teaches us that even the children don't. Maybe this is even a bigger consequence, that she will think twice before trusting this one witness, and really do some investigation to make sure that she is fully confident that her husband is really dead. Otherwise, the consequences may pass on even to her children, who will not collect the ketuvah. Good. Achiv shel zeh v'achiv shel zeh cholsin velo meyabemin. If either of the husbands die without children, and she's alive, she becomes a Yevamah. And so she would have to do something. And the Mishnah says they would have to do chalitza and cannot do yibum. So let's analyze each case. Achiv shel rishon choletz mideoraita. The first husband, she's fully married to. They did a complete marriage, and until the time that he went away, they were totally married. So if he dies, that's a full marriage, and so you need to do chalitza mideoraita. Velo miyabeh midrabanan. Why can't she do yibum with one of the brothers of the first husband? So really on Doraita level you could, because there was a full marriage. But the rabbis say, no, we don't want you to do that. Drabanan, knas. Because of the second guy. Achiv shel sheni choletz midrabanan velo miyabem lo midoraita velo midrabanan. Now how about the second guy? Really the second guy she was never married to at all, because she was married to the first, so that kiddushin, but the second guy was nothing. So therefore really she shouldn't have to do anything with the second husband. If the second husband dies, the second husband's brother should not have to do yibum or chalitza, because they were never actually married. And so why do you need chalitza? So in this case, it's chalitza is midrabanan. So you have to do, the rabbis say, do chalitza, right? It's yet an extra penalty. But you can't do yibum, because not on a doraita or the rabbanan level, no way that you could do yibum. Good. That explains that case. We just explained it according to the Setama, the Gemara, based on the Bizera. The Peshat of the Mishnah would say that actually there is a marriage. There is a valid marriage to both husbands, and therefore both equally would require, if either of the husbands died, there would be a zikah on a deoraita level. But because you have a contradiction, this paradox that she's connected to two men at the same time, therefore you'd have to do chalitza and not yibum. So it will be required deoraita on both cases. But in the Gemara's understanding, it is derabanan. Okay, now we get to the biyose omer ketubata al nichse ba'ala. Let's look at this again. We have here three opinions. Actually, look at this one. Okay, we have three opinions here, three minority opinions. The biyose says ketubata al nichse ba'ala rishon. He thinks that, in fact, the first marriage is strong enough that she can collect the ketubah from the first husband. Okay, Rabbi Elazar says that the first husband can collect the anything that she finds or her earnings, and he can undo her vows. So again, he's saying that the first marriage is still in force. So they seem to be in agreement, and the Gemara is going to discuss, do they agree with each other or not? We're going to see both ways. The third, Rabbi Shimon, says that the first husband, if he dies without children, then his brother can, if the first brother does yibum or chalitza, then any co-wives that the first husband had can go free. In other words, the yibum or chalitza from the first husband is effective. And if she goes back to her first husband and has children, the child is not a mamzer. So all three of these are emphasizing the continuing validity of the first husband. Unlike Tanakama, that says no, you cannot. She doesn't get any of these things. All right. So now, since they are all on some similar page, would they agree with each other or not? So we're going to see two ways. Ketubatan Isebala Amar Rav Huna Batra'e Module Kama'e. Kama'e lo module batra'e. The first version, the first opinion of Rav Huna is that the opinion, the third, agrees with the earlier ones. The third agrees with the second agrees with the first. But not the other way around. The first will not agree with the second, and second will not agree with the third. Okay, how does this work? Let's see. Rabbi Shimon, he's the third one. Modele Rabbi Elazar. He agrees with the one before. Dema bi'adi kadisura lakanes. Rabbi Shimon's the one that said you can do yibum. So if yibum, which is the main prohibition, bi'ah is the main prohibition, and there the rabbis did not make a kanas. They said, okay, you can do yibum. Rabbi Shimon thinks that the brother of the first husband can do yibum. So if that's true, then all the more so, Rabbi Shimon, the third opinion, will agree with Rabbi Elazar, the second opinion, that something that she finds or her earnings, that is just money. So that's more lenient than bi'ah. So if that bi'ah with the avam is permitted, then certainly Rabbi Shimon would agree that she can keep her money. But the other way around is not true. Rabbi Elazar would not agree with the third opinion of Rabbi Shimon regarding Yibum, because he would say regarding findings and earnings, that's just money. So the rabbis will be lenient. Lo kanis, they did not make a penalty. Aval bi'ah tisurahu kanis, but bi'ah, that's a serious prohibition. So there they would make a penalty. The whole point of this thing is that she had the illicit bi'ah, and so therefore she can't go back to her husband. If she can't go back to her husband, she can't be with the avam either. So that's a more serious thing. All right. Now both of these two, the second and third opinion, they both agree with the first opinion of Rabbi Yosef that she can collect her ketuvah at the end of the marriage. These the matters that they discussed is that are something that she collects while they are both living. When her earnings, while she is alive and he is alive, she gets. So if that's true, then all the more so she should collect the ketuvah, which is the exit document. So if we're not going to penalize her while they are still married, then certainly we're not going to penalize her for getting out of the marriage. That's the whole point. We want her to get out. However, Rabbi Yosef will not agree with the other two sages, because he will say regarding the ketubah, I say let her have the ketubah. She'll be happy to leave, because we want them to leave. But the others, the findings and the earnings, that she would collect while they are still married. But that was what we want to penalize, because we want them to stop being married, and so don't give it to her. So then that'll give her extra incentive to leave. All right, all that is the opinion of Rav Huna. However, Rabbi Yochanan says exactly the opposite. Rabbi Yochanan Amar, Kama'e module batra'e lo module kama'e. The first opinions agree with the ones after them, but the last opinions do not agree with the earlier ones. So they go in the opposite order in terms of stringency or agreement. So now we're going to have to argue everything we just did with an opposite argument. So this takes a lot of skill to come up with opposite arguments all the way through. Here we go. Rabbi Yosef modeh Rabbi Elazar. Rabbi Yosef, who said that she collects a ketubah at the end, would agree with Rabbi Elazar that says she keeps her earnings. Ketubah demedideh ledida lakanis. If a ketubah which goes from him, he gives it to her, and the rabbis did not make a knas and said he has to give it to her, then kol sheken then all the more so her findings and earnings that are given from her to him. Now, if we allow her to collect the ketubah, then all the more so she doesn't have to give him something, the earnings. Okay, so he doesn't agree. But Rabbi Elazar will not agree with the first opinion of Rabbi Yosef. The rabbis only do not make a penalty regarding her earnings and findings, because that would go from him from her to him. So there, if she has it already, we don't make a penalty to say that she has to pay him. But a ketuvah that goes from him to her, there, why should she collect? So we don't let her collect from him, but if she has something that she has already, she can keep. So that's why Rabbi Elazar will not agree with the earlier opinion of Rabbi Yosef. And both of them, Rabbi Shimon, the first two opinions, will agree with Rabbi Shimon that she can do yibum with the first husband's brother. These first ones, the findings, that is something that the rabbis did not penalize, and that happens while the husband is alive. So if you didn't penalize him, if you didn't penalize her while the husband is alive, then all the more so, bi'ah of yibum, you will not penalize after the husband is dead. The whole penalty is because, look, they're in a prohibited marriage, and we got to stop this, we got to get him out of this marriage, but now he's dead, so it's finished. There's no need to continue penalizing her on account of him after he's dead. So therefore she can do yibum. The first would agree with that. But Rabbi Shimon lo madu lehu. But Rabbi Shimon would not agree with the first two opinions, because he would say bi'ahu de lachar mita lo kanis, aval hanim de mechaim kanis. Only bi'ah where the rabbi is lenient, because that's after the death of the first husband. So he's already out of the picture. So all those prohibitions we had, those problems are gone. So therefore, we do not need to penalize her. Go, let her do yibum. That's fine. But these other things that she collects while she is alive and he is alive, then that you need a penalty. She should not be able to collect her earnings. And the ketubah that would be given to her at the time of divorce when he is alive, all those things she should not get, because that's the whole point. We want to penalize her to get her out of that marriage, out of the situation. Okay, so that's a very good point about the relationship between these various opinions. Okay, so now we understand this relationship, and now we're going to go to the sefa. So if she got married without permission, and the Bavli understands this, the Stama understand this as meaning, what do you mean without permission of the Beit Din? So based on what? Based on two witnesses. Okay, so the Resha is one witness with permission of the Beit Din. Sefa is two witnesses without permission of the Beit Din, and says she can go back to him. The Gemara right now is going to understand this as a continuation of Rabbi Shimon's words. Rabbi Shimon says all this, and he says that if she got married without permission, meaning with two witnesses, she can go back to the first husband. So let's analyze this section. Niset shelo b'rshut. Amar Rav Huna, Amar Rav, hachi hilcheta. Rav Huna said in the name of Rav that we follow this halacha. Good. She got married with two witnesses, even without bet and without Beit Din. So, and then the husband comes back. So we say, well, she did this on her own. She wasn't she didn't get a stamp of approval from the Beit Din, but she relied on two witnesses. So what was she supposed to do? She did the right thing. So in that case, we say, oh, you know what? The second husband is nothing, and let her go back to the first husband. Okay. Amar le Rav Nachman, Genava genuve lamalach. Rav Nachman tells Rav Huna, why are you saying your opinion as if you're a thief? Why are you hiding your real, what you're really saying? Why are you saying in a strange way, like you're holding back something? What are you saying? If you're saying this is the law, that we follow this law, that if she got married without permission of the Beit Din, she goes back to her first husband. Who says that? Rabbi Shimon says that. So therefore, you should just say, I think halacha is like Rabbi Shimon. And why you're embarrassed to say that you're following a minority opinion? So you're saying this is the law. You don't want to quote that you're saying Rabbi Shimon? Okay, good challenge here. Now, no, here's the problem. If I say, if Rav would have said, or Rav, when the name of Rav would have said, halacha is like Rabbi Shimon, it would sound like he agrees even regarding the first halacha that she could do yibum with the first husband, and that the child is not a mamzed if she goes back to the first husband. He doesn't agree with Rabbi Shimon about that. So if that's the case, then you still could have said it. You still could have formulated with Rabbi Shimon and say, I agree with Rabbi Shimon's second point, that if she got married without permission, she can go back to the first husband. And you could have said it like that, and so we leave this as a difficulty. All right. Amar Rav Sheshat. Amina ki nayim v'shachiv Rav amara leha shemateta. Halacha mikelada plige. Mai hava lam leme'avad mi'anas anasa. Okay, the statement of Rav is now challenged once again by Rav Sheshat. And he says, a fantastic phrase, he says, I think Rav must have said this while he was dozing and falling asleep. Right? He wasn't paying attention to what he was saying. It's not an exact thing. By saying that the halacha is like this line, that if she got married without permission of the betin, but based on two witnesses, she goes back to the first husband, she can remain with the first husband. If you're saying that's the halacha, it implies that there's someone who disagrees. Is there anyone who disagrees? Nobody disagrees with that. What was she supposed to do? She is total honest. There was two witnesses that said, we saw your husband is dead. So you don't need any more proof than that. Two witnesses is like infinity. It would be the same as if it was totally against her will. She did everything right, and she went and got remarried. She doesn't deserve to be penalized. It would be the same as if a woman was raped violently against her will. What do we say to her? As long as she's not married to a Kohen, we say it's not against her will. It's not her problem, not her fault. So she can go back to her first husband. Should be the same thing here. Nobody would disagree. So why does Rav have to say, oh, I think the halacha is like this? No one disagrees with that. Ve'od Tanya. And furthermore, we have a braita that says so. Kol arayot shebatorah en tzrichot menuget chutz me'eshet ish nishet al pi bet din. You see, this braita says, regarding all illicit, forbidden relations in the Torah, they do not require a get. If someone has illicit relations with a close relative, they don't need a get. If someone is married and she commits adultery with someone else, she doesn't need a get. There's no way that to affect a marriage with any of these prohibited relations, except for Eshet Ish, that who got married based on Betin. That's the Resha of the Mishnah, that if the Betin gives their stamp of approval, then that gives some effectiveness to the second marriage. This is the Peshat of the Mishnah, right? You see it here in this Baraita. Gives some effect, and therefore she needs a get. So what do we derive from here? Al pi betin, hu debaya get. Only when the betin approves the second marriage, then it has serious standing. She requires a get, even if the first husband was alive the whole time. But al pi edim, lo baya get. If it's only based on witnesses, then she does not require a get. If the betin didn't say this marriage is good, the second marriage, she got married on her own with two witnesses, so she did everything right, and therefore, and the betin did not get involved. Therefore, it's total unwitting adultery, and she does not require a get because the second marriage was nothing, and if she doesn't require a get, she can go back to her first husband. And so you see that this supports the fact that everyone agrees to this. Okay, this Baraita, thus in sum, says that in the second case of the Mishnah, when there are edim and no betin, no get is required. No get is required is equivalent to saying she can go back to her first husband. So this Baraita, which is anonymous, if we can prove that this is the opinion of a Rabbanan, then that means everyone agrees to this law, and that's the basis of Rav Sheshat's challenge that Rav must have been sleeping when he said halacha is like that line in the Mishnah, that she can go back to her first husband. Everyone agrees to it, because after all, this Baraita is agreed to by Rabbanan. All right, now it's going to get slightly complicated, so let's put some labels. Let's call this Baraita A, right? Baraita A that says, and we inferred from the Baraita that in the second case of the Mishnah, al pi edim, she does not require a get. So that means that this is agreed to by everyone. Now what we're going to do is say, wait, hold on, maybe, in fact, this Baraita is only the opinion of Rabbi Shimon, and therefore it's not agreed upon by all. That's why I've had to say, I agree with this halacha. So, maneh, ilem Rabbi Shimon, let's see if it fits Rabbi Shimon's opinion. Al pi betin, mi baya get, here's the problem. Rabbi Shimon, we're going to quote a second Baraita, we'll call it Baraita B. And Baraita B is going to show that Rabbi Shimon is even more lenient than this Baraita, in that he does not require a get, not even in the first case of the Mishnah. With the permission of the Betin, still doesn't need a get. How do we see that? V'hatanya, Rabbi Shimon Omer, Asu bet din behoratan, kizdon ish be'isha. When the Bet Din gives a decision, and they say, oh, there's one witness or whatever, based on whatever they decide, they say you can go and get remarried, then that is like the woman committed adultery on purpose. Why should that be so? The Bet Din said she can do it. Yeah, but the Bet Din used only one witness, not sufficient evidence, so therefore she should have been more careful and investigated. Therefore, we make it as if it's on purpose, and therefore she cannot go back to her first husband. But if it's based on witnesses, al pi adim, that's the and not betin, that's the sefa, kishigegat ish pisha, then it's like she did it by mistake, unwitting. If it's unwitting, then she can go back to her first husband. That's the end of Braita B. The point of this is that ed la baya get. In neither case do you require a get, because even if a woman commits adultery on purpose, so yeah, she can't go back to her first husband, but she doesn't have to give a get to the second one. So you see, Rabbi Shimon cannot be the author of this baraita, because this baraita A requires a get in the first case, just not in the second case. If this is not Rabbi Shimon, then who is the author? Elalav Rabbanan he. Therefore, this is in fact this baraita A is Rabbanan, and that proves that everyone agrees that in the second case no get is required. Therefore, Rav, everyone says what you said. Why do you even need to say halacha is like Rabbi Shimon when in fact it's not Rabbi Shimon only? You see, Rav Shesha seems to be reading that line of the baraita as its own line, right? As not the opinion of Rabbi Shimon, but rather as a separate line. And so everyone agrees. So you don't have to say everyone agrees with the halacha is like something that everyone agrees to. Okay, so this is the challenge, and here's a little chart so we can follow the arguments coming up. We just had Baraita A, and we said Baraita A is the same as Rav's Pesach, because it says that Braita A says that in the Resha of the Mishnah, when permission is given for Betin, then you require get from the second husband. But the Sefa, when there's two witnesses without permission, then you do not require get from the second husband, which also implies that she can stay with the first husband. Now, that was Braita A. Rav Shesha's challenge is that Braita A is by Rabbanan. We just proved that. And everyone agrees to that. So why did Rav have to come and say, oh yeah, I think the halacha is like this? That's already the opinion of Rabbanan and Rabbi Shimon. Everyone agrees to this line. We showed that because in Braita B, Rabbi Shimon says there's no get in either case, not even in the first. So this Braita can't be Rabbi Shimon, it has to be Rabbanan. That's the basis of the question. We're going to see 4 answers now. The first 3 are going to reread Braita B, so that Braita B can equal Braita A, and therefore we can say Braita A is only Rabbi Shimon's opinion, not Rabbanan. Rabbanan would disagree with the whole thing, would disagree with both parts of it, and would say you require get in both cases. And so that's why that supports Rav. That's why he had to say halacha is like the Sefa, because that is only the opinion of Rabbi Shimon. So that's the first 3 are going to reread Braita A. The last is going to reread Baraita, because first these 3 are going to reread Baraita B to fit with Baraita A, and the last one is going to reread Baraita A. So it's going to add a word to it, a vav actually, and that way the rereading Baraita A will actually say you need to get in both cases, and in that way we can see that this Baraita does not say that there's no get required. You do need a get, and that would be the opinion of Rabbanan, and the Rabbi Shimon again here disagrees with Rabbanan. So in either all 4 responses will say that Rabbi Shimon is the author of the last line, and he disagrees with the Tanakama, with Rabbanan, and that's why Rav had to say what he said. Okay, so let's go to the first rereading of Baraita B. That will show that in fact, Rabbi Shimon agrees with this case. He doesn't say no get in both cases. No, that's not. He never said anything like that. Le'olam Rabbi Shimon he really Baraita is Rabbi Shimon. V'taris hachi, and explain Baraita B as follows. You had the wrong formulation. Rabbi Shimon omer asu betin behora'atan kekavanat ish be'isha u'bayaget. When there is only one witness insufficient evidence, and the Bet Din says, okay, you can go ahead and get married, then they deem the marriage that she has with the second husband as if it's with intention of kiddushin, and therefore it's established as a good marriage, and she requires a get from the first husband. She does require a get from the first husband. This is how it's different from the original formulation. And al piyadim shelo bekavanat ish beisha v'la ba'yaget. But if it's based on only witnesses that she gets married to the second guy without the permission of the Bet Din, then we treat that her connection with the second husband, that bi'ah, as if they did not have intention to marry, and therefore it was just adultery, unwitting adultery, and she does not require a get. And so this, where you require a get in the first, in case A, and not in case B, that's the same as Baraita A. So therefore, Baraita A is only the opinion of Rabbi Shimon, and it's not unanimous. Okay, that's one rereading. Second rereading of Rabbi Shimon. Rav Asher Amad, Le'inyan Isura Katane, Baraita B was talking about the prohibition. V'achi ka'amad. Asu betin behoratan kizdon ish be'isha umit tasera al ba'ala. It's not talking about get at all. It's only a question of, is she prohibited to be with her first husband? So if the Bet Din got involved and they said, yes, you can get married to the second guy, then that is like she committed adultery on purpose, and in such a case, she is not allowed to return to her first husband. Good. If it's based with Bet Din, if it's without Bet Din, but based on just witnesses, then that's like unwitting adultery, in which case she is allowed to go back to her first husband. And so that's what Rabbi Shimon says. She can go back to her first husband in the second case. But it's not talking about requiring a get or not. It has nothing to do with a get, so there's no contradiction between Baraita A and Baraita B. Baraita A can very well be the opinion of Rabbi Shimon. She requires a get in the first case, but not in the second case. Next, Ravina Amar Linan Korban Katane. Ravina says that whole Baraita B is talking about her requirement to bring a korban, and it was not discussing not get and not being not going back to anyone. Asu betin baratan kizdon ish bisha vela matya korban. When the betin said that she can get married to the second guy, then it is like, was she committed a sin on purpose? When you do something on purpose, you don't bring korban. Korban is only for shogeg, and therefore she does not bring a korban. In our case, she doesn't bring korban because the Bet Din takes responsibility. They're the ones that have to bring the korban for issuing a false ruling. Al pi adim keshigigat ish bisha umatya korban. If she relied on edim without the Bet Din, then that's like an unwitting adulterer, where she has to bring a korban because it was shogeg. In this case, also, Baraita B has nothing to do with a get, and therefore it's no challenge at all to Baraita A, and so Rabbi Shimon very well could be the opinion, the author of Baraita A, that says, yes, unlike the original reading, she does require, original reading said no get in either case. In all three of these readings, yes, even Rabbi Shimon would agree, she requires a get in the first case, just not in the second. So this is the author of this Baraita A is Rabbi Shimon, not Rabbanan. Rabbanan would say she requires a get in both cases. And that's why Rav has to come and say, oh, wait, I think that Rabbi Shimon is right. She does not require a get. She can stay with her first husband. All right, that's the first three answers. And the last answer, in fact, the Baraita A is Rabbanan. But you read it wrong. We're just adding a vav here. And by adding a vav, what we're saying is that everyone needs a get except for two cases. Instead of just one case, the original reading was except for Eshet Ish, Sheniset al pi betin, who got married based on betin, meaning only she does not require a get, right? The Baraita A said that, let's read it again, and no one needs a get in general, except for Now, the original reading says, except for one case, someone who got married, sheniset al pi betin. So when you got, that's resha, then you do need a get. Only in the resha you need a get, but in the sefa you do not need a get. That was the original reading. But now by adding a vav, we're giving two exceptions. Nobody who is in prohibited relation needs a get from that prohibited person, except for two cases. One is eshet ish, and niset al pi betin. Well, niset al pi betin, that's resha. Eshet ish is the sefa, when she goes ahead and she, on her own, based on two witnesses, remarries the second guy. That's eshet ish, and requires a get because it's part of the chutz. And so, therefore, this baraita, in fact, is the opinion of Rabbanan, but the baraita itself says that a get is required in both the resha and the sefa, because that's what the baraita says, and that's the opinion of Rabbanan. It is not the same as Rabbi Shimon, and therefore Rav had to come and say, "Oh yes, you absolutely halacha is like Rabbi Shimon and not like Rabbanan, because according to Rav there is a machloket between them." The final section of the daf is absolutely fascinating. We're going to analyze the statement that Rav Sheshet said. Rav Sheshet was pushing to say that everyone agrees that in the sefa of the Mishnah, in the case where she had two witnesses, that's full proof. And she goes ahead, because she doesn't need betin, she didn't need to consult betin if there's two witnesses, and she goes ahead and gets remarried, and then the first husband comes back. So we should allow her to remain married with the first husband. And he thinks everyone agrees to that, because after all, what else could she have done, right? She did everything properly. She doesn't deserve to be penalized. So this is a kind of a moral argument based on reason that is very interesting. And now Ula is going to challenge it. Mativ Ula, mi amrinan mai hava la leme'evad Rav Sheshet. Can we really apply this principle of moral fairness? I mean, it makes sense, but he's going to bring now 6 cases where, although there was nothing that the woman could have done, nevertheless, just as a consequence of the situation, she does suffer because of it. So here's case number 1. V'hatanan Mishnah Gitin says, Katav l'shem malchut she'ena hogenet, l'shem malchut madai, l'shem malchut yavan, l'binyan habayit, l'churban habayit, haya b'mizrach v'chatav b'ma'arav, b'ma'arav v'chatav b'mizrach. If someone writes a get, but there's a problem with the get. If he writes the date in an improper format, he writes it for not the right kingdom. You have to write the date according to wherever you are. If you're an Israelite kingdom, you write to the king, king of Judea. If you're in Persia, you write to the Persian king. So if you write to a kingdom that is not the right one, for Madai, for Yavan, who are long ago are gone, or to the building of the Bet HaMikdash, or the destruction of Bet HaMikdash, that's not to the local government. So all these are improperly formatted dates. Or you put the wrong place. You wrote the place in the get, that this get is being done in the east, but actually we wrote it in the west, or actually wrote it in the east. In all these cases, the get is invalid, but she thought it was valid, right? She receives a get. She may not know all the intricacies of the proper formatting. She received a get. She thinks it's proper in front of Bet Din, and she goes ahead and she gets remarried based on that. Then, after some years, someone opens up the get and says, hold on, there's a problem here with the get. It's not formatted properly. Well, now what? She actually was married to the first guy the whole time, and now the second husband, and maybe she had children with the second husband, are all problematic, all adultery. She has to leave both, and she gets all of the penalties that we already mentioned. That's what the Mishnah says. So Ula asks, why, according to you, Rav Sheshet, why don't you apply the principle of what could she have done? She did everything properly. She doesn't deserve any of these things. And so, therefore, you see that principle is not true. However, Rav Sheshet can answer. He says, she should have read the get. I mean, she's responsible for making sure that the get is properly formatted. If she's not knowledgeable and studied all the laws, then she has to show her lawyer. Show someone you trust. That's the way it is with contracts. If you sign a contract and you didn't realize that there's a clause in it that's going to make you liable, you still are responsible for that clause. You have to read the contract first. So it's unfortunate for her, but she is in fact responsible, and therefore it does make sense that yes, all the penalties apply in such a case. All right, so Rav Sheshet was able to answer that one. Second case, Amar Rav Shimi bar Asher Tashema. Here we go, a second case. Hatkoneset Yevimto v'alchav sarata v'nimset zo ailonit. A man dies without children, and his brother, the Yavam, marries, does bi'ah with the Yevamot, does yibum. And now the co-wives of the deceased can go and free, because one of the co-wives, did yibum, so then the other co-wives will go ahead and get married. Turns out after some time that the Yevamah was an Ailonit. Ailonit cannot perform yibum, and therefore the Yavam was no one did yibum. Therefore, the co-wives are still on the hook. Because they still have a connection to the Yavam, and they were not allowed to go ahead and get married. And now we have a big problem. What's the result? The co-wives who went and married another guy, they have to leave all those guys, and they have to get all of the penalties here. And we ask, what else could they have done? It's not their fault. They saw, look, one of the co-wives of the original husband who died did yibum, so now we're all good, right? They did everything right. Why do they deserve all these penalties? And the answer is, they should have waited to see if the one who did yibum turns out to have a child, and she's not an Ailonit, or maybe wait till she shows signs of that she is an Ailonit, and then wait, don't get remarried yet, and if she is an Ailonit, then one of them will have to do yibum or chalitza. So she should have waited, and therefore she is somewhat responsible. So now we uphold the principle that if it's really totally unfair, then she doesn't deserve it. But here she bears some responsibility. Third challenge, Amar Abaye Tashema Kol Arayot Shamru Potrot Sarotehen. In general, anytime you have a case where the Yavam is related to one of the potential Yevamot. For example, if a man married his niece and he dies without children, so then the father doesn't do Yibum, and not only does he not do Yibum with his daughter, all the other co-wives are permitted to go and marry whoever they want. Now let's say you have a case like that. Halchu Sarot v'nisu. So the co-wives, they say, oh look, one of our co-wives is related to the Yavam, so now we can all go and remarry. And they do. Nimsu elu ailonit. But let's say the one that's the daughter, or any of the ones that are related, turn out to be an ailonit. In that case, the marriage was retroactively never good, because mekach ta'ut, the man here says, would you have married her knowing that she's an ailonit? No, I never would have married her. Therefore, since that daughter was never actually married to the deceased, those co-wives require Yibum or Chalitza. They still have retained their Zikah to the Yavam. And so therefore they weren't allowed to go and get married. So the result is, and so they have all this list of penalties. And now we ask, we should say, what was they supposed to do? They looked everything right? They looked up the law. The law says if one of the wives is related to the Yavam, then you don't have to do anything. They followed the law. How could they expect that daughter would become an Ailonit? And the answer is, they should have known this is possible, that she'd be an Ailonit, then you'll be in trouble. You better wait to see if either she has a child or she develops signs of Ailonit, and only then have gotten married. So she was somewhat responsible for these penalties. Next case, Amaravat Tashema Katav Get. Katav Sofer Get. La'ish v'shovar la'isha. When a couple gets divorced, they're going to go to a professional scribe to write it. The scribe writes a get for the man, because the man is going to take the get from the sofer, and he's going to give it to the woman. So that's why he needs to get it. And he also writes a shovar, a receipt to the woman. The woman eventually, after the man gives the get to her and pays the ketubah, she will give the receipt to the man, so he will have evidence that he paid the ketubah, so that she cannot come and say, oh, you didn't pay me the ketubah, you have to pay. No, look, you gave me a receipt. So that's the general thing, the way it works. However, ta'ah, v'natan get la'isha v'shabar la'ish, but the scribe made a mistake, and he gave the get to the woman, and the receipt to the man. And v'natnu zeh lazeh, and the woman, she gave the get to the man, thinking it was a receipt. He gave her, not thinking it was a get, he gave her a receipt, not the get. So she never actually got her get. And in the meantime, they don't open it up. I guess they were closed, they were sealed. And ulachar zman hareh haget yoseh mitachat yedei ha'ish v'shavar mitachat yedei ha'isha. In the meantime, she went and got remarried because she thought she was divorced. She has her divorce in her hand. But after some time, after she's married, they opened it up and they find that the get is actually with the man. She gave the get to him. They're not divorced in such a case. And he gave the receipt to her. So she was never divorced. Her second marriage is all adulterous, and all the other penalties will apply. According to you, you should say that this doesn't make sense. She doesn't deserve the penalties. What should she do? She went there, she did everything correctly. And the answer is no. She should have read it first. Right? Before you sign something, you got to read it. Make sure, is this the same version of the document that we agreed to before? Right? Did the right one print out from the printer? You're going to sign, the wrong one. You got to read it right before you give it to make sure it is in fact the right one. So yes, true, the sofer made a mistake, but she's responsible to make sure that she did in fact receive her get. Amar Rav Asher Tashema Shina Shemo Ushma Shem Ira v'Shem Ira Teseh Mizeh Mizeh v'Chol Haderechim Ha'elu Ba. If in the get you have the wrong name, his name or her name, or the name of the place, his city or her city, all these things are requirements in the get for it to be valid. If any of them are wrong, then the get turns out to be an invalid get. She didn't know. She thought it was a good get, and she went and got remarried. And turns out it was not a get. She was never divorced. Also, she gets all these penalties. We could say, what was she supposed to do? And the answer, we already saw, she should have read the get to make sure that it was correctly, shown it to her lawyer. That's what you have to do. You see that we're answering the same answers for each of them. Why are we asking so many questions if it's going to be the same answer again and again? We're going to see why in a second. Amar Ravina Tashema. There's something called a regular get, a bare get, as opposed to one that's sewn together. A regular get is like any contract. You just write it and you sign it at the bottom with two witnesses. But the rabbi said, you know what, this get is not, we don't want people to use that, especially if they're a Kohen. Because if a Kohen gives a get, he can never change his mind and remarry that woman. So the rabbi said, we want to use a more complex and safer version, where you take the parchment, and after you write some lines, you fold it, sew it, and you need a signature of a witness. You do that again and again, at least 3 folds with 3 signatures. The reason is because this takes a long time to do, and hopefully by that time, the husband, especially if he's a Kohen, will calm down and say, you know what, I don't want to give the get. So we prolong the process for that reason. So the rabbi said you have to use this type of sewn get, not a kereach get. What if you do use a kereach get and she didn't know? And she didn't realize, so then she has to get divorced. It's it's an invalid get, and yet she gets all the penalties. And the answer again is she should have read it and realized that it's an invalid get. She should have consulted with an expert if she doesn't know the laws to say, oh no, you can't use this form. You have to use the other type. And therefore, she is responsible for it in all those cases. So, technically, Rav Sheshat is upheld. He answered all 6 problems. And so, theoretically, right, if you find a case where she really had no responsibility, she checked it, she read it, there was no way she could have done anything to prevent the problem, then Rav Sheshat still stands. And in fact, Rav Papa in fact followed this reasoning in a case that came before him. It doesn't tell us the case, but it was a case where there's nothing that she could have done to prevent this outcome, and therefore Rav Papa was lenient and said, okay, you don't get the penalties. Amar le Rav Huna bered Rav Yoshua Rav Papa v'hatanya kol haneh mataniyata. Rav Huna comes and says, look at the sugya that we just learned, and you see we have all these mishnayot, these 6 mishnayot that challenge the rule of Rav Sheshet, that we say nothing that she could have done. So this all these 6 challenges. Why are you still following the rule? Amar le velav shaninhu. Rav Papa says, yeah, but we answered all of them. So since we gave responses, and my case was not a case where she could have read it or should have realized. So therefore, I went by the rule of Rav Sheshet. Amar le vashinuye leku v'lismoch. Rav Huna Rav Yoshua says, and are we going to really rely on all these answers? I mean, these answers, the point is, even though we answered all 6 of them, the more challenges you have, the weaker and weaker becomes Rav Sheshet's principle that, oh, well, what could she have done? So even though if it was only 1 challenge and you answered it fine, but 6 challenges shows that, yeah, you could answer it, but the answers are rather weak, and therefore we're not going to really want to rely on that basic principle. So I think this explains why we gave so many challenges, right? Again, poking holes, and yeah, you can keep answering it, but once there's more exceptions to the rule than the rule actually applies to, then you say, you know what, we can't really rely on this rule. This is a very important methodological principle in many sugyot where you have many challenges. Even if they're all answered, when you're going to come to decide halacha l'maaseh, you can say, well, they answer all the questions, so we should follow that halacha. Not necessarily. The fact that it gave so many challenges may be an indication that should not be the halacha. And so this is absolutely fascinating discussion where you have explicit moral reasoning to judge a case, and the question is, can you apply that moral reasoning? Sometimes, yeah, but sometimes it's just the consequences of the reality of the case that unfortunately will lead to difficult results. Baruch Adonai Olam, Amen ve'amen.